All rise. Veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à assesser les functions résiduelles du tribunal pénal at Oued.
Please be seated. Before starting today's proceedings, may I ask everybody will be pleading not to resort to speed reading. It's very difficult for the interpreters. I realize that you have very limited time and you have a very heavy mandate, but please let's bear in mind the interpreters. There were some real problems yesterday, so let's try to avoid it today. So let us now start today's proceedings. Registrar, would you please call the case?
Thank you. Good morning, Your Honor. This is case MICT 1355A. The prosecutor was Radovan Karadžić.
Appearances for the parties' prosecution.
Good morning, Mr. President. Your Honors, for the prosecution, Katrina Gustafson, Elizabeth Elmore, Laurel Begg, Barbara Goy, and Ian Reed. Thank you.
Now, counsel for Mr. Karadžić.
Good morning, Mr. President, members of the Appeals Chamber. Peter Robinson, along with Kate Gibson and Goran Petronijevic for Radovan Karadžić.
And Ms. Gibson, I'm so sorry I did not mention you yesterday.
No offense taken at all, Your Honor.
I apologize. And now, before going to Mr. Karadžić, I would like to ask two questions, one of each of the two parties. Let me start from defense. Yesterday, the prosecution argued that because of the role of the legal advisor of Mr. Karadžić, a very important role, if I may add, the chamber had no special responsibility to ensure his rights were protected. I mean, his rights as self-representing appellant and accused earlier on. Do you agree with the prosecution? That's a question for the defense. And now I turn to the prosecution. You will recall my question yesterday concerning whether the trial chamber relied on the large number of adjudicated facts to enter convictions. Ms. Gibson stated that there were 36 convictions for the scheduled incidents that relied solely or in significant part only on untested evidence. I realized that in your argument yesterday you referred to some aspects of that, including that those determinations were not made solely on the basis of those of the untested evidence. But I would like a fuller response from the prosecution to the specific points made by Ms. Gibson yesterday. Now, both defense and prosecution can simply edit to address these questions when they have the floor. So we will now turn to Mr. Karadžić for his reply till 11 o'clock.
Hvala, dobro jutro, Excellency. Pardon.
Thank you. Good morning, Your Excellencies.
Ms. Gibson.
Good morning, Mr. President and Your Honours. I'll be commencing our submissions in reply to the prosecution's response to our appeal on the question of the fair trial issues, after which Mr. Robinson will address you on the question of Srebrenica, and then again President Karadžić on issues relating to Sarajevo and the municipalities. I'd like to start, I think, with your question from this morning about addressing the prosecution's submission that the trial chamber had no special responsibility to ensure the fairness of these proceedings because during the trial, President Karadžić was very ably assisted by a legal advisor. I would disagree that any suggestion can ever be made that the trial chamber's duty to ensure a fair trial would ever be reduced or mitigated because of the scope of or quality of the legal representation and the assistance that he's receiving. What is clear is that when an accused elects to represent himself, as is his right, there have been various procedures put in place at the different trials as part of the trial chamber's duty to ensure that the trials are fair, even though the accused has chosen this particular course of representing himself. In the Milosevic case, for example, it was an amicus curiae to assist Mr. Milosevic. In the Stankovic case, for example, a special counsel was put in place to cross-examine particularly vulnerable witnesses in the place of the accused. In this case, the trial chamber made a decision, which was upheld on appeal, that President Karadžić would be assisted by a legal advisor. This in no way meant that it's the trial chamber's right to ensure the fairness of the proceedings was mitigated. The point yesterday by the prosecution, as I understood it, was raised particularly in respect of the argument of parliamentary privilege. The prosecution is arguing on this appeal that the appeals chamber has no authority to decide that question because President Karadžić didn't squarely put the issue before the trial chamber in the trial phase. Our argument in our appeal brief, and we only went as far as to say the appeals chamber certainly has the discretion to consider points that haven't been raised at trial, and in the past they have done so in particular when an accused has been self-representing. That is not to indicate that President Karadžić wasn't ably assisted at trial. It was just a reference to the fact that in other cases the appeals chamber itself has said we will address and engage with this issue, and one of the many reasons we will is that the accused was self-represented. Our submissions only went to that extent.
Thank you.
If I could turn then firstly to the question of self-representation, the prosecution argued yesterday that President Karadžić's, and I quote, only rationale for testifying in narrative form was to save time. That's at the transcript of yesterday, page 172, lines 7 to 8. This is incorrect. Twice, President Karadžić made the link between narrative testimony and self-representation. In his filing of 18 December 2003, which is referenced in footnote 9 of our appeal brief, in which he confirmed that he wanted to testify in narrative form, he cited to a US Court of Appeals decision which affirmed that a self-represented accused could testify in narrative form. His legal advisor then made the same link to the trial chamber on the 20th of February 2014, where he said, "You have essentially imposed me as his counsel for the purposes of his testimony." And I reference transcript T45935, referenced at footnote 16 of our appeal brief. To say that President Karadžić's only rationale for testifying in narrative form was saving time is not correct. The prosecution is also wrong to criticise President Karadžić on the basis of, and I quote, he never even responded to the prosecution's written submissions on this topic, with reference to page 171, lines 17 to 18 of yesterday's transcript. President Karadžić had 14 days to respond to the prosecution's submissions. The trial chamber's oral decision was rendered 6 days after the prosecution's filing. And you have to remember that this all happened in the very dying days of the trial. And after 5 years of evidence, the trial chamber's foot was firmly on the accelerator. President Karadžić can't be blamed for the trial chamber's failure not to wait the time period for him to respond. The prosecution was also incorrect yesterday when it said that it would, and I quote, add that the defence this morning incorrectly claimed that we made no reference to Karadžić's self-representation in our trial submissions. That's at page 171, line 25, to page 172, line 1. This again is incorrect. Our submission, which I'll repeat verbatim, is nowhere in this filing did the prosecution acknowledge that in imposing counsel on President Karadžić for the purpose of his testimony, they would be restricting a fundamental right of the accused. Of course the prosecution mentioned self-representation. That's what the issue was about. Everyone was alive to this question. The defence had raised it. The prosecution had responded to it. Our point is what was missing from the discussion and what was never done was a balancing of the restriction of this fundamental right in the manner laid down by the appeals chamber in Milosevic. And I'll make reference to the Milosevic case's decision on the interlocutory appeal of the trial chamber's decision on the assignment of defence counsel from the 1st of November 2004, paragraphs 17 to 19. Turning then to disclosure. The prosecution's submissions yesterday on disclosure were a textbook example of the perpetrator blaming the victim. There is no question that President Karadžić was overwhelmed by disclosures during the trial that should have taken place in pre-trial. And it's amazing that the prosecution can assert as an argument, well, it's not 500,000 pages of delayed Rule 68 disclosure that was late. It's only 250,000 pages of disclosure that was late. Even if that's right, which we dispute for the reasons in our appeal brief, and even if President Karadžić was given 4 months to review this delayed disclosure, that's still over 2,000 pages for him to read and analyse per day. But that's not even close to being the point. President Karadžić should have had this before the trial started. The accused has a right to prepare his defence based on a full picture of the prosecution's evidence, inculpatory and exculpatory, incriminating and exonerating. The prosecution's admission that it was only searching for exculpatory evidence proximate to a witness's testimony, which it didn't dispute in its submissions, is indefensible. As early as the Furungia case in 1998, it was recognised that an accused can suffer prejudice if he proceeds on a trial strategy that was developed pre-trial without the benefit of proper disclosure of the prosecution's evidence. And I make reference to the Furungia decision referenced in footnote 72 of the Karadžić reply brief at paragraph 19. My learned friend was also wrong to assert that the defence suggested yesterday that, and I quote, the trial chamber sat back and did nothing. The reference is at page 173, lines 23 to 24. No such suggestion was made. Yesterday, we pointed out the remedies that the trial chamber took, but said that they were insufficient because they had no impact on the prosecution's case and did nothing to stem, let alone stop, the disclosure violations, the most recent of which revealed itself last Friday, April 20, 2018, when the prosecution disclosed yet another untimely record of a witness interview that was dated 2003 and is 9 years late. Turning then to adjudicated facts. The prosecution's response yesterday on this ground failed to engage in any way with the defence position on appeal that the volume of adjudicated facts made this trial unfair. Again, the prosecution simply repeats that the case law has repeatedly affirmed that the adjudicated facts regime is consistent with the rights of the accused. We agree that's what the case law says. That's why we're here trying to change it. And if we can't change it, we can at least demonstrate how regimes that can be consistent with the rights of the accused can also be implemented in a way that is not, that is manifestly unfair. The prosecution's submission did not engage with this central point on ground 7. As to General Mladić's testimony, again, the prosecution misrepresents President Karadžić's submissions by saying that the defence submitted that the prosecution could have set up a firm Chinese wall. And the reference is at page 180 of yesterday's transcript, lines 14 to 15. We never said that. We have no idea if the prosecution can set up a firm Chinese wall. We're saying that the prosecution said in Stanisic that it could. And now if it's saying that it can't, then it should reorganise itself so that it can. And we agree with the prosecution that, and I quote, Karadžić's right to present a defence does not translate into an absolute right to elicit every piece of potentially relevant evidence. The reference at page 183, lines 5 to 7. But this wasn't a piece of potentially relevant evidence. This was General Mladić. For 20 years, the prosecution's narrative of these events has had President Karadžić and General Mladić hand in hand. Mladić's words and actions and notes in his diary and even hearsay evidence of gestures he apparently made were deemed relevant and important and probative enough to make adverse findings against President Karadžić throughout the judgment and to base the form of his convictions. This was not a piece of potentially relevant evidence. This was seminal and it was available, and it should never have been kept out of the record of this case because of the structural integration of the Office of the Prosecutor. Concerning parliamentary privilege, the prosecution still hasn't offered a reason why parliamentary privilege should not apply in international proceedings. Again, yesterday it just emphasised that the appeals chamber doesn't have the right to decide this. We argued yesterday and again in our briefs why in our submission the appeals chamber both can and should. But the prosecution only gave you a partial picture of President Karadžić's legal advisor's submissions before the trial chamber on this issue. Yesterday, my learned friend made reference to transcript T43094 to T43095. And she is correct that the trial chamber asked President Karadžić's then legal advisor whether the defence was claiming a privilege in respect of Karadžić's parliamentary statements that would preclude the trial chamber from admitting them in this case. And it is correct that he said no, not at all. And so the prosecution submits that this was a narrow decision that pertained only to whether Karadžić's statements, whether Karadžić could be questioned on these statements in this trial. But we invite the appeals chamber to continue reading. And Mr. Robinson continues, as long as he, meaning Mr. Karadžić, as long as he is not questioned about that, then I don't think in this context the privilege is violated by admitting it against Dr. Karadžić. But if it were to be a trial of Mr. Karadžić, it might be a different situation. And I refer to transcript of the trial 43095. The defence never said that a parliamentary privilege wouldn't prevent the admission of a parliamentary statement in an accused's own trial. And in fact, in this response, he indicated the opposite. But if it's unclear whether or not this was a general ruling or a ruling specific to Karadžić, then let's look at the trial chamber's language. And I refer to T43150, where the trial chamber said, while immunities and privileges may protect parliamentary statements in domestic jurisdictions, this does not apply in international criminal proceedings. On a plain reading, the trial chamber is saying this, being the protection offered by parliamentary privilege, does not apply in international criminal proceedings. This is definitive, it's broad, it's general, but in any event, even if the appeals chamber finds that President Karadžić didn't raise this issue on appeal, didn't raise the issue squarely at trial, he's raising it now on appeal. And the appeals chamber has a discretion to consider it. Turning briefly then to ground 31, a conviction of an accused cannot be based solely or in a decisive manner on untested evidence. The trial chamber in this case convicted President Karadžić of 15 scheduled incidents based solely or in a decisive manner on evidence admitted under Rule 92 bis. It convicted him of 6 scheduled incidents based solely or in a decisive manner on adjudicated facts. It convicted him of another 15 scheduled incidents based solely or in a decisive manner on a combination of Rule 92 bis and adjudicated facts. And I'd refer to the citations in our appeal brief at paragraphs 554, 555 and 556. Yesterday, the prosecution said that each of the scheduled incidents established by Rule 92 bis were corroborated by other evidence. And it referred to its table at paragraph 119 of its response brief, in which it purports to list all this evidence that apparently corroborates the untested 92 bis evidence. This table misses the point for 2 reasons. Firstly, much of the corroborative evidence that's cited is just general patterns of conduct in certain municipalities. It doesn't help in determining whether a specific scheduled incident occurred or who the perpetrators were or if there's any link to the accused. That's why it's not listed as corroborative in the judgment. The prosecution pointing to it now in 2018 as being, in its view, corroborative doesn't engage with the central error, which is that the trial chamber didn't find it or didn't rely on it or didn't consider that it was corroborative. But in any event, this table doesn't establish that the trial chamber didn't rely on untested evidence solely or in a decisive manner to form the basis of a conviction. If you take yesterday's example from the prosecution referred to scheduled incident A14.2 and said, yes, the trial chamber did rely on Farid Sparhich's untested 92 bis evidence, but according to the prosecution, it also relied on a variety of other evidence which corroborated Sparhich's account. The findings on scheduled incident 14.2 can be found in paragraphs 1080 to 1093 of the judgment. In those paragraphs, the trial chamber's findings cite to 55 footnotes, 55 references to the evidence. Of these 55 refer to Sparhich's Rule 92 bis evidence. 4 footnotes refer to both Sparhich's untested 92 bis evidence in a combination with the variety of the evidence that the prosecution pointed to yesterday. So the trial chamber convicted President Karadžić on scheduled incident 14.2, relying in a decisive manner on this statement. For this conviction, and in fact for each of these 36 convictions raised under ground 31, this was the case. Moving lastly to ground 29, and the impact of the decision of the Supreme Court of the United Kingdom in the Prosecutor versus Jogi on JC3 at the ICTY. Of course, we agree with the prosecution that the Appeals Chamber has consistently upheld the ICTY's formulation of JC3, including just a few months ago in the Perlich appeal. In none of these cases was the Appeals Chamber asked to reconsider this specific aspect of the doctrine in this court in light of the reasoning in the Prosecutor versus Jogi. That's what we've asked the Appeals Chamber to do in this case. With your leave, Mr. President, I'll turn the floor to lead counsel to continue our arguments in reply.
Thank you, Mr. Gibson. Mr. Robinson?
Thank you, Mr. President. First of all, I owe an apology to the interpreters and the court reporter. I was probably the biggest offender yesterday of the speed. I have my sign this morning.
You were only one of them.
Okay. I have a sign this morning for my benefit. Now I'm going to try to remind myself of it, but I have to tell you I got a lot of adrenaline going, so I can't promise, but I'll do my best. Look, let me poke 20 holes in the prosecution's argument for Srebrenica, and then I'm going to sit down. Number one, the prosecution said there was a false premise that the Karadžić-Deranić intercept was important and that it was primarily used to mark the timing. That's at transcript page 203. That's not how we read the judgment, and we're not alone. Days and weeks following the trial chamber's judgment, something remarkable happened. Along with the usual celebratory accolades from NGOs and victims groups heralding President Karadžić's conviction, 3 articles appeared from respected academics expressing disquiet about the thin evidence used to convict President Karadžić of genocide in Srebrenica. Among them were Marko Milanovic of the University of Nottingham, Professor Kai Ambos from Göttingen University in Germany, and Professor Milena Stereo of Cleveland Marshall Law School in the United States. Their criticism of the judgment, which they saw hinged on the interpretation of that cryptic intercept, are referred to in our opening brief in paragraphs 733 and 34 and 771. And Professor Stereo subsequently wrote an article published in the Emory Law Review in which she suggested that since it was so difficult to prove mens rea in President Karadžić's case, that perhaps courts ought to simply admit that it will apply a relaxed standard when it comes to high-ranking officials such as President Karadžić. And you can find that article at 31 Emory International Law Review 271. Number 2, the prosecution says that President Karadžić's praise for those who carried out the Srebrenica operation shows that he knew of the executions. Page 204 of the transcript. This is senseless. President Karadžić fired General Mladić 2 weeks after Srebrenica. At the assembly session in early August, he had to justify firing General Mladić. If he knew that Mladić had led an execution of 5,000 prisoners, he had more than ample reason to fire General Mladić, or even to convince General Mladić to resign. That was the testimony of Defense Minister Milan Ninković at page T40510. But President Karadžić didn't do that because he had no knowledge of the executions. Incredibly, President Karadžić tried to take credit himself for the Srebrenica operation. In a television interview of the 4th of August, he said that General Krstić had planned the Srebrenica operation in front of him. And in a speech at the Assembly on the 15th of October, President Karadžić said that he personally supervised the plan for Srebrenica. President Karadžić is not stupid. These efforts to personally take credit for the Srebrenica operation are inexplicable if he had knowledge of the executions. Number 3, the prosecution says that President Karadžić received written reports from the field during the Srebrenica operation. Yes, he did. He received a daily report from the Army main staff, regular reports from the Army's Security Service, led by General Tolomir, and regular reports from the Ministry of Interior. The prosecution has those reports. There is not even a single mention, not even a hint, that the prisoners had been executed. If President Karadžić had been in on it or ordered the executions, there was no reason to keep this information out of the reports being sent to him. Number 4, the prosecution says that President Karadžić received a report from Police Commissioner Dragomir Vasic, who was in the field, about the Srebrenica operation. That's page 208. Yes, he did. The prosecution has that report. It makes no mention or even hint of executions. Number 5, the prosecution says President Karadžić received an oral report from a field commander about the progress of the column of men leaving Srebrenica. Yes, he did. But there is not a shred of evidence that that report included even a hint that the prisoners were being, would be, or had been executed. Number 6, the prosecution says that President Karadžić received oral information on the executions from General Mladić in a telephone call of 13 July. There were 3 Americans who were present during that call, one who listened on the other line. All 3 of them testified there was no discussion whatsoever about the prisoners, and the idea that prisoners would be executed was simply incompatible with what they had heard. And that's T26080 through 82, T27406, and Exhibit D2905, paragraphs 32 and 34. Number 7, the prosecution says that President Karadžić was told about the execution by Deputy Minister of Interior Tomislav Kovač, with whom he met on the 13th and 14th of July. It's on page 207. But Kovač testified that he never informed President Karadžić of any executions because he didn't have information about them. That's D3960, paragraphs 129 and 124, and page 42, 792 of the transcript. Number 8, President Karadžić, according to the prosecution, was told about the executions by Zvonko Bijagić, a member of the Bosnian Serb army with whom he met on the evening of the 14th of July. But Bijagić testified that he never informed President Karadžić about any executions. That's D3853, paragraph 36D. Number 9, the prosecution says that President Karadžić was told about the executions by Milenko Karasic, his Director of National Security, with whom he met on the 16th of July. But Karasic testified that he didn't know of any executions and never informed President Karadžić of them. That's D3749, paragraph 63. Number 10, the prosecution says that President Karadžić was told of the executions by Deranic on the 14th of July and must also have been informed by the leaders of Srebrenica municipality with whom he met later that day. But there's no evidence from Deranic on what was said at that meeting. In fact, 3 days later, on the 17th of July, Deranic faxed President Karadžić a statement signed by Robert Franken of UNPROFOR and Mr. Manzic, one of the Muslims who had been in Srebrenica, that the evacuation had been conducted smoothly in accordance with the Geneva Conventions and international humanitarian law. That's P4185. And the leader of the delegation who attended the follow-on meeting, Dane Katanic, and Assembly President Momčilo Krajnik, who also attended the meeting, both testified that there was not even an inkling from that long meeting that any prisoners from Srebrenica had been executed. That's D3561, paragraph 8 for Katanic, and page 43, 352 of the transcript for Krajnik. And the prosecution now tells us that Krajnik was the other president referred to by Vieira when he mentioned 2 presidents. That'll be a shock to Krajnik. He was prosecuted for years at this tribunal and never charged with having anything to do with Srebrenica. No one even put that to him in our trial when he testified as a defense witness that he had ordered getting rid of the prisoners of Srebrenica. That's an absolutely baseless speculation and ought to raise cautionary flags to you as to how far the prosecution is willing to substitute pure speculation for fact. Number 11, the prosecution claims that President Karadžić promoted General Krstić on the 13th of July. Yes, he did. But there's no evidence he had any knowledge of any killings, which in any event had not started yet. The general who brought Krstić's papers for President Karadžić to sign on the 13th of July, Petar Skrbić, testified that there was no discussion of execution of prisoners. In fact, we tried to call everyone who had any contact with President Karadžić during those days of 13 through 17 July to testify. Those included persons on President Karadžić's immediate staff, such as his National Security Counselor, Gordon Milanic, his military advisor, General Bogdan Subotic, his political advisor, John Zamatica, and the Secretary General of his cabinet, Mile Dimičić. It also included persons who were recorded in President Karadžić's calendar as having met with him during 14-19 July, including President Krajnic from the State Assembly, State Security Director Dragan Kijac, Minister of Defense Milan Ninković, State Secretary of the Ministry of Defense Dragan Kapatina, Vladimir Matović, an aide to the former president of Yugoslavia, American journalist Robert Djurjevic, American professor Serda Trifkovic, Canadian businessman Milan Lesic, and French journalist Yves Bataille. All of them testified that President Karadžić gave no indication that he knew prisoners would be, were being, or had been executed. Even if President had contact with people like Derenic, who did have knowledge of the executions, you can't just assume that they informed him of the killings. In the Krstić case, the appeals chamber reversed a finding based on an inference that because a person had been in contact with someone who had knowledge of the killings, that person must have shared that knowledge. The trial chamber had inferred General Krstić's knowledge of the plan to execute the prisoners due to his many contemporaneous contacts with General Mladić. The appeals chamber reversed that finding, holding that, and I'm quoting, despite the trial chamber's assertion that if General Mladić knew about the killings, then Krstić must also have known, the trial chamber did not actually establish from Krstić's contacts with General Mladić during the relevant period that Radoslav Krstić, in fact, learned of the intention to execute the Bosnian Muslims as a result of those contacts. The trial chamber's assertion was without a proper evidentiary basis. Likewise, in our case, the finding that President Karadžić learned of the executions from Derenic or anyone else was without a proper evidentiary basis. Number 12, the prosecution...
Could you just excuse me for a second?
Yes.
Please proceed. I'm sorry, but
No problem. I won't charge you for that time.
I happen to have presided over Krstić. I'm not quite sure that I completely agree with your reconstruction of that, but we will come back to that.
Okay, and I was quoting from paragraph 98, if that helps at all. Now, the 12th point, the prosecution said that President Karadžić's declaration of war provided for excavations and applied to the entire area of the Drina Corps, including Zvornik. That's at pages 209 and 210. That's just wrong. That declaration of war said nothing about excavations, and it applied only to Srebrenica and Skalani municipalities. The reference to the forces of the Drina Corps are only because those municipalities were in their zone of responsibility.
Kindly slow down for the interpretation. Thank you.
Didn't expand the declaration of war to Zvornik municipality, and I invite you to look at Exhibit P4553, the declaration of war. 13. The prosecution says that that declaration of war was issued after Karadžić's meeting with Derenic on the 14th of July, and he informed him of the executions. That's also wrong. The Republic Communications Center log shows that that declaration was issued and distributed at 11:55 a.m. on the 14th of July. That's Exhibit P2803 at line 340. Derenic's meeting with President Karadžić didn't even start until 12:40 p.m., according to President Karadžić's calendar. That's Exhibit P2242 at page 91. 14. The prosecution says Karadžić lied to David Frost on the 17th of July when he was asked about 15,000 men missing from Srebrenica. Page 211. In fact, President Karadžić's interview with David Frost confirms that he had no knowledge of the prisoners being executed. When Frost asked him about 15,000 men missing from Srebrenica, President Karadžić answered that they were in this large column and many of them would reach Muslim territory today or even tomorrow, and that they would soon be accounted for. That's P5235 at pages 2 and 3. Now, had he known those prisoners had been executed, it would be foolish and counterintuitive to claim that the people he knew to be dead would be showing up today and tomorrow. Point 15. The prosecution says that President Karadžić spared the local UN staff to avoid international scrutiny. That's ridiculous. These local staff had been in Potocari. They'd seen the separation of the men and may have even seen some of the executions around that White House. If President Karadžić knew of the executions and the plan to execute the men, he had no reason to release these people. The prosecution says, number 16, that President Karadžić knew of the reburials. Page 211. There's no evidence whatsoever of that, and they didn't cite any in their briefs or in this hearing. While the prosecution was able to find an authorization signed by General Mladić for the requisition of fuel used in the reburials, they never found a single piece of evidence that provides any indication whatsoever that President Karadžić knew of any digging up of graves or reburials. 17. The prosecution says that since prisoners ended up in Zvornik, Karadžić's reference to somewhere else in his conversation with Derenic must have referred to Zvornik. That's reading history backwards. I gave you the example yesterday of an allegation that the president and prosecutor Brammertz discussed the merits of the Šešelj case in the lobby. Well, Šešelj ended up having his acquittal reversed and being convicted. Would that make the allegation that the president and prosecutor had been discussing of the merits of the case any more true? Number 18. The prosecution says that the intercept corroborates Nikolić. How would he know that Derenic had talked to Karadžić earlier that day? That's at page 216. The answer is that Nikolić got that intercept and disclosure long before he made the plea bargain and decided what he would tell the prosecution. Nikolić arrived in the tribunal on 2 April 2002 as a defendant and made his plea agreement more than a year later in May 2003. Number 19. The prosecution said that the chamber used the utmost caution in evaluating Nikolić's evidence. I don't find a single place where they declined to rely on Nikolić's evidence. They even found that his testimony about Mladić's hand gesture, which Mladić's own trial chamber rejected, was true. And they found that Nikolić had informed Colonel Blagojević of the killings, a fact that Blagojević's own trial chamber rejected. And the prosecution hasn't pointed to another case in all of international criminal jurisprudence where someone was convicted on the uncorroborated testimony of a participant in the crime that had made a plea bargain with the prosecutor. President Karadžić's case stands alone in that respect. And point 20, the prosecution discounts the references we've made to the judgments of other trial chambers like Mladić, Blagojević, and Krstić as not being applicable to this case. It's a strange position for a prosecution that urged our trial chamber to take judicial notice of almost 3,000 adjudicated facts from other judgments because those findings were so reliable. Those judgments are instructive. You have to decide what a reasonable trial chamber would have done, and what better yardstick to measure reasonableness than what other trial chambers have done under similar circumstances. And other trial chambers have uniformly found it was unsafe to base a finding on the responsibility of the accused on the testimony of Momir Nikolić. The prosecution's effort to dress up President Karadžić's conviction as something more than Momir Nikolić's uncorroborated testimony are smoke and mirrors. This is an unsafe conviction. It should be reversed. Now I'll tell you that I have concentrated all my efforts in this appeal on this one ground, much to Ms. Gibson's chagrin. And I've done that because I wanted to emphasize it, because it's important. If you do nothing else in this appeal, you have to overturn this conviction. This is one for the ages. Someday, some intercept from the United States or some other information will come about and prove conclusively that President Karadžić didn't know anything about these executions. But in the meantime, you have to decide the case on the record that's before you. And it would be a miscarriage of justice if you decided that case that this record was sufficient and safe upon which to convict President Karadžić of genocide. Thank you.
Mr. Robinson, you really made a valiant effort to present an argument as you did. It's a difficult argument to make for you. You are in fact suggesting that there was a very efficient and overarching conspiracy of silence by all the senior officers concerned to hide things from President Karadžić, despite his mandate, his efficient control of the apparatus, etc., etc. You are suggesting that everybody, including General Tolimir, and we know the judgment which we issued on him, participated in this conspiracy of silence, if I may call it. Would senior officers have any interest in creating a record of incriminating evidence, either of what had transpired in writing or in oral? Were there not multiple ways in which senior officers could communicate to Mr. Karadžić what was planned, A, and B, what happened later? It's a very difficult propositions that you advanced.
Yes, I understand that point, Mr. President, that it's hard to believe that President Karadžić would not have been informed by somebody of these executions. But in fact, there's a background to that, and that is that in 1993, in April, when the military had tried to take Srebrenica, and General Morion was there trying to make it a safe zone, it was President Karadžić that stopped that. They were angry with him for that, and there's been evidence in our record of that. And the relationship between President Karadžić and those military leaders, Mladić, Tolimir, and others, was not very good and very trusting as of 1995. In fact, there's evidence President Karadžić dismissed Tolimir and Biara even before the Srebrenica events. So while in a normal military and commander-in-chief setting, you would expect them to work hand in glove, There's ample evidence in the record that that wasn't the case here. And that's why your proposition is logical, it doesn't actually fit the individual facts of this particular case. Thank you.
Judge Sekula has a question. Judge Sekula.
Thank you, Mr. President. And I want to understand, and Mr. Robinson, or as well as the prosecution, okay, I just want to help me to understand. Is there any dispute with regard to the alleged execution that may have happened between 13th July, is that so? 13th July to 17th July in Srebrenica, in particular in Dubrovnik. What is the alleged number of the people alleged to have been executed or killed in that area? Can somebody help me? I'd like to be interested to know the number without inferences anywhere, but I just want to know what is the position of the parties and the evidence with regard to that aspect alone during that period of time. Number, if execution did happen, how many during that period of time? And it might help me to understand.
Yes, thank you very much, Judge Sekula. I believe the number is 5,113. That's what the trial chamber found, the number of people executed after the fall of Srebrenica. We disputed that during the trial, but we don't raise it as an issue on appeal, and it's not part of our arguments on appeal here. Perhaps the prosecution might want to add to that.
Yes, prosecution.
Thank you, Judge. The prosecution agrees that in the trial judgment they found a very conservative number of 5,115 bodies.
Thank you.
So in fact, the answer given by both defense and the prosecution is that there is no dispute that at least this number was involved.
Yes, that's what I wanted to know.
That's correct, isn't it?
Yes, for the purposes of this appeal, that's
Thank you,
correct.
Mr. Robinson.
Dobro jutro svima, hvala.
Good morning to everybody. Thank you, Excellencies. If I may just add to what has already been said, I wondered and asked myself, how was it possible for this to be hidden for so long, such a drastic incident? One of the perpetrators revealed here in the courtroom why. Dražen Erdemović, a Croat in our military ranks, who was assigned to do that. An alleged colonel who was leading that already in May was dismissed from the army. If it was that person, I dismissed him, not because of suspicions for a crime, but due to ideological missteps. This was not committed by any unit. This was done by ad hoc gathered groups at some level. I asked Erdemović, how was it possible that this was not known? Who did you speak to somebody about this? And he said only with two associates who would not speak about that to Pelemiš, meaning one of the commanders of the most immediate detachment. How did this happen? Why? There was fear, shame, confusion, and when I ordered on the 1st of April 1996 for the military prosecutor to investigate everything, he replied, I investigated, nobody knows anything over there or does not wish to know. And this document exists in the case file. Well, this much about Srebrenica. I am in awe of the skill of Mr. Robinson, and I would not wish to add anything further. I would briefly like to comment on what was said by the prosecution yesterday. I am grateful to the learned ladies from the prosecution for repeating completely and strengthening the pattern in which the prosecution worked in this case. Everything was upside down, the wrong way up, with a lot of speculation and various claims to which we should just bow our heads and accept guilt. However, even though this was their defense yesterday, the decision by the trial chamber and justification of the judgment, there are a few things that I would like to look at again. It was said that I allegedly gave insincere explanations to my collocutors from the United Nations that our operatives operating the artillery were inexperienced. However, there is a report by Tadija Manojlović, the artillery commander of the Sarajevo-Romania Corps, which is ascribed to me as well. I'm being charged for that statement. He said also, in the beginning, we didn't have any experts. We did not have trained crews for the weaponry, so there were mistakes and waste of ammunition. A large number of civilians at the Markale market on the 5th of February were casualties in an empty market where you couldn't see anything on the stalls. And there were 500 people there. How is this possible? Why were they there? One of the unusual things there is how was it possible that among those killed there wasn't one single salesperson? There had to be at least 2 or 3, or an average 2 per stall person who was selling their goods. Not one single salesperson was reported as being killed. Measuring the angle of descent by diagrams on the ground is laughable. Berko Zečević is an interested party in this. He's a Muslim official, an official in that army. And so if by an illustration or a drawing of fragments on the surface, one would be able to determine the direction and the angle of descent, then nobody would have any need to preserve the channel and in that way establish the angle of descent. It was said that a Serb artillery person confirmed that 30 to 40,000 shells were fired at the city from his firing position, and that there were many such firing positions all around Sarajevo, both Bosniak and Serbian ones. Had that many shells been fired from just one firing position, Sarajevo would look worse than Dresden. The crews went from one hill to the next, and then both sides would fire at the trenches, the lines, or possibly infantry in the process of attack. This mustn't be glossed over, and the trial chamber should not be put in a position to be horrified by the number of 30 to 40,000 shells from one place. According to what was reported, there was an average of 2,000 to 3,000 shells, 2,000 shells in 1,400 days. This would come to, actually, you can see for yourself, this would amount to millions of shells fired. Sarajevo would have been razed to the ground had it been exposed to even 10% of that. The shells were moved from hill to hill. Their guys and our guys fired at the lines and at the firing positions.
Concerning the JCE, it was said yesterday that Bosnia was on its way to independence. Bosnia had no such right, not without our consent. In paragraph 3447, the prosecution cites the judgment saying that designated, selected municipalities were taken, and that by 1992 they were cleansed. But that is wrong. Before the war, in all the documents, you can see that Serbs were the majority population in 65% of the municipalities. None of the municipalities shown by the prosecution yesterday was entirely controlled by the Serbs. Those were Serb settlements, Serb neighborhoods within these municipalities. Almost each of them, before the war, was negotiating on transformation into a community of 2 or 3 municipalities. That was my intention and the intention of the Bosnian Serb leadership, not to separate the population, but to administratively segregate populated centers to avoid a rise in tensions. So when Vojca Mlađenović said, cited in the judgment, said, we have gathered, assembled all the Serb municipalities in Foča, that should be exculpatory. Foča was the largest community in Yugoslavia. The plan was to have a center of the Muslim community and a Serb municipality, where each community can exercise their rights. The greatest clashes were in Foča, Rogatica, Vlasenica, Bratunac, and Zvornik. All the 5 municipalities were in the process of transformation, which was stopped by the SDA. And one European-oriented lady, Rabia Šubić, wrote a letter to Izetbegović complaining that it was his fault. Everything that happened was his fault, because if he had let Muslims and Serbs reach an agreement, none of that would have happened. Why Serbs in control of so much territory would have been prepared to concede some of them if they were at the same time fighting to take over others? I have said 100 times, do not take other people's property. And you have a letter from Momir Bulatović, president of Montenegro, communicating to Milosevic that I had told him, why on earth did you take Jajce? There were very few Serbs in Jajce. There were a few problems with water supply and power supply, but we could agree with the Croats, and there were no major problems. In those municipalities, the reality is that not the municipalities were in question, but neighborhoods. 1/4 of Pale where I was based, was a Muslim municipality throughout the war. We could have taken it if we had wanted it. Foča, not entirely, but a good part around Ustikolina is still a Muslim municipality. Furthermore, we have had procedural objections, namely that I did not explain what I would achieve by examining a particular witness and I didn't lead particular evidence. Your Excellencies, it never crossed my mind that the trial chamber would accept and criminalize my actions that were taken strictly in accordance with the law and the Constitution of Bosnia-Herzegovina. All that is black on white. We're talking about organized forces, forces controlled by the state. We did not do anything that was not prescribed by the legislation, which even envisaged penalties for failing to take such action. There was a lot of reference to late disclosure and my intention to delay. I did want prolongations and extensions, but not at the expense of properly preparing my case. There were many violations of Rule 68. I cannot explain to you well enough how much prejudice was done to the defense. Such informal meetings. On the 19th, I had to travel by car to Belgrade. On the 20th, I was to fly to Lisbon and stay there until the 27th. And then remain in Belgrade until the end of the day of the 30th. There are records of my meetings with foreign representatives, the American ambassador, with President Milosevic, etc. If his interview had been disclosed to me in time, and it was disclosed to me after the trial was over, and that interview was given to the media, the entire trial would have gone a different way. Let me just give you one example. There was an opinion floating around here that Arkan should have been put on trial even had there been no criminal complaint filed against him. In our system, that is not possible. If a report of the European Monitoring Mission had been disclosed earlier, where they say they wanted to interview Arkan, but first wanted to talk to the Muslims in Bijeljina who had direct experience of Arkan, then the trial would have proceeded differently. And the Muslims said they at first celebrated Arkan because he had stopped the bloodshed and was kind to them. Arkan, like Mauser, was an arrogant man. But Mauser eventually was commended. Karadžić commended Arkan only in 1995 when I allowed him to defend Republika Srpska as part of the Ministry of the Interior, and he did that honestly and well. Yesterday I was astonished at the amount of words that can be produced without being based on anything, that are pure slander. that preconceptions and suspicions are more important than evidence. It can be inferred, allegedly.
Your Honor, could we move into private session just for a second?
Yes, you would have something to say?
Yeah.
Yes, we will close the hearing for a moment to make it private. The registrar, please. Are we now in open session?
We are now in open session, Your Honor.
We are in open session. Mr. Karadžić, you may proceed.
Ekscelencije, I u javnim dokumentima i u
Your Excellency, also in public documents and in the judgment, this number, KDZ, is publicized and it doesn't reveal anything that hasn't been revealed before. But let us continue. It was said yesterday that after the 14th July, there is no mention of prisoners of war. When is there mention of them, except in December 1994, when Manjača camp was disbanded? These are routine matters. When Deranić informed me that there were 2,000, I believe he was exaggerating because he wanted me to lend him some assistance in terms of guards. But such people were easily replaced. We simply couldn't feed so many people. Discussing prisoners of war was a routine matter, completely under the law. The prosecution didn't explain why 50 pages of our final brief are never mentioned in the judgment, as if we hadn't said a word. There is absolutely no reference to it, as there is no reference to many exculpatory elements that are present even in the testimonies of hostile witnesses who were confronted with certain documents and then accepted and confirmed these exculpatory elements. At the very least, many of them cast a shadow of doubt, an absolutely sufficient shadow of doubt to justify the application of the principle in dubio pro reo. The prosecution says that I did not call certain witnesses or did not show the profit in examining them. That cannot be done. That can only be seen from the judgment. I was astonished by the judgment because it concerned certain matters that are beyond any doubt, that shouldn't have been mentioned at all, let alone as an incrimination. As for reports from the army, I received regular reports along the chain of command. All the lower ranking units send reports to superior units that are accumulated in the main staff, and then I am informed just enough to be able to communicate with foreigners and plan the further development of the army. But if I did put certain questions, it was because I needed to have information. If my foreign interlocutors tell me that something had happened somewhere, I should be able to give an answer. If we had waited for the results of our investigation, then I wouldn't have been able to respond on the spot. The prosecution took it as an admission of my guilt. They say he didn't deny. How could I deny? I first had to check. There was talk about my personal control over access. It's clear that I was not even able to contact with anyone from the army at the time of Srebrenica events. This would be my brief overview of the prosecution's comments yesterday. As for Sarajevo, there are hundreds of exhibits showing that Sarajevo was a stronghold of the Muslim army whose aim was to take over all of the city and expel the Serbs from Sarajevo. After that, the Serb part of Sarajevo on the periphery became a military stronghold of the Serb army, whose aim was to defend that part of Sarajevo, not take over the entirety of the city and the whole of Bosnia-Herzegovina. The documents of the United Nations are unambiguous, especially those drafted by the highest officials of the United Nations. And they confirm what I say. Let me just give you a reference. A UN report D366 reporting on what the BH army and the Bosnian Serb army respectively are doing and intending. They say about the BH army:
continue to apply pressure to disrupt BSA lines of communication and strengthen their links to the Srebrenica and Gorazde pockets in eastern and north Bosnia. Apart from short-term benefits, any significant gain against these routes would strengthen their position in upcoming negotiations. They would also assist in ensuring BSH compliance with territorial agreements and place BH Army forces in an advantageous position for a resumption of hostilities, which they probably regard as inevitable. A Sarajevo offensive is unlikely to be successful without substantial Croat support. It is the absence of this support that has probably delayed its launching and has contributed to the interfractional tensions among the BH forces. BH Army forces may be prepared to launch an offensive using their troops without Croat support if they believe their position in peace negotiation is so weak they must provoke foreign intervention. U istom dokumentu.
In the same document, the following is said about the Serbian army.
In Sarajevo area.
Excuse me just for a second, Mr. Karadžić.
D336.
Thank you very much, Mr. Karadžić. Please proceed.
No major developments should be expected in the Sarajevo area without unacceptable casualties. The capture of the city is an unattainable objective for the Serbs. The BSA will remain in a defensive posture and rely on its superiority in indirect fire weapons to deflect any BH army offensives. Ogroman je broj dokaza.
There is a vast number of evidence that Serbs were exclusively in a defensive stance in Sarajevo, exclusively in a defensive stance. And there were about 35 major Muslim offensives, and altogether, including minor ones, there were a total of 53. And I'm not talking about daily exchanges of fire, but about artillery preparations and infantry attacks on the inner and the outer rings. And now we have a document which in paragraph 4644 talks about how the trial chamber described and concluded the nature of the conduct of the Sarajevo Romania Corps, that it was a siege, even though a siege is something that happens in war, and we were the ones on whom war was declared. Defense is legitimate. However, things were not as described. This is what is said. The Muslim side misused the Sarajevo front in order to block talks, to suspend them when they wanted to, and so on. And in D1496 of the 6th of January of 1993, it's a document by the UNHCR, and it notes some examples by the Human Rights Watch.
Be invited to address this protest to the government of the Republic of Bosnia and Herzegovina, who are at present responsible for the continuation of the siege of Sarajevo. Kada se uzme u obzir.
If you take into account our constant efforts for demilitarization of Sarajevo and for placing Sarajevo under the authority of the United Nations and the Muslim refusal of those proposals, it is clear who was the side that needed the Sarajevo suffering. There is a vast number of documents and evidence that that was so. And here is what the commander of the Muslim army at the time, Sefer Halilović, said. This was a meeting.
Da, nažalost, da.
Yes, unfortunately, yes. This is because I lack the skills to summarize everything. Anyway, these are minutes of a meeting of the Presidency of the Bosnia and Herzegovina. This is 122nd session of the 17th of June, before they declared war on us. And this is what Halilović said on page 4. He talks about how they had already taken over Mojmilo Hill, that they intended to liberate, actually to capture Novo Sarajevo and Ilija, and to integrate that into Sarajevo, and then Lukavica, and so on and so forth. And then he says the following about the forces in Sarajevo.
Sarajevo region consists of the following: the regional territorial defense staff in Sarajevo region, 2 batteries of 120 millimeter launchers with 12 pieces of the weaponry, batteries of 105 howitzers with 5 pieces, 122 millimeter artillery platoon, 3 pieces, armored mechanical platoon, APCs, and so on and so on. They have 16 municipal territorial defense staffs and 500 independent platoons, around 450 companies and armored anti-sabotage platoon, and so on and so on. Sarajevo
had 275 staffs and command posts. We never fired at them, and General Milosevic, when asked why not, he said, we only returned fire at the weapons that fired at us. And then the observers who did not know the deployment of forces characterized that as indiscriminate fire. I would have a lot more to say, but the fact is that we can find in the documents of the case evidence that there were no criminal plans in existence, that there was no homogenization of civilians, but only of territories. And the most instructive here are the documents mentioned yesterday, P12, P92, and P938. I don't have time to show these documents now, but these documents are my speeches at conferences when it's clear. And I would kindly ask you to study those documents when it was clear that there would be 3 Bosnias, and I'm asking for discipline, for order, and so on and so forth. And I say that each village would have the opportunity to decide where they wanted to be, and so on and so forth. I just wanted to also look at paragraph 4642 of the judgment. It says,
from the fact that plurality of persons acted in unison, furthermore, the plan need not be previously arranged or formulated, but may be realized later on, i tako dalje. Isto se tako kaže da, opet inferenca.
And again, another inference, no proof, an inference that you could infer due to the duration and due to the plurality of persons. This is wrong. In racial and ethnic conflicts, all members of a threatened or attacked community have no alternative but to defend themselves, either to defend themselves for as long as possible, or even to seek to defeat their enemy, or to be defeated and to disappear. How is it possible not to see that Serbs in Sarajevo and in Bosnia and Herzegovina were in favor of peace? They made desperate concessions and backed down, and ultimately the international community from the day one recognized the right to Republika Srpska from day one until Dayton, and this was codified at the United Nations. But before that, there were tricks from the other side, which were successful, and they inflicted a lot of harm to us and to them. While waiting for an international intervention, the Muslims exposed their people to enormous casualties and suffering. Thank you, Your Excellencies.
I'm sorry to interrupt, Your Honor.
Sorry?
I'd just like to seek some clarification. I'm, of course, able and ready to respond to your questions at any time, but I'd just like to confirm that I would still have my 30 minutes to present the prosecution appeal.
But in principle, we are supposed to absorb answers to questions, but I will give you an extra few minutes. So we will now have a break of 30 minutes.
All rise. Voyez-vous lever.